In this segment, I will discuss some legal considerations in making employee selection decisions. I will discuss several laws that have been implemented over the years and address issues of discrimination for various groups. In our employment process, this is both step 2 and 3. History has shown us that there has been rampant discrimination and mistreatment of workers. People would be hired or not because of who they were. Potential workers were routinely and openly not hired because they were Black or Asian or women or disabled. It has required instituting laws to encourage employers to treat workers and potential workers fairly. Fairly in the case of hiring means paying attention to what is a valid predictor of performance, rather than other characteristics of a person that are unrelated to the work. In most cases, this includes things such as sex, race, and religion. We often think of the Civil Rights Act of 1964 as the first and primary legislation to eliminate employment discrimination. However, there was discussion and to some extent some action prior to this. The problem with early actions is that executive orders were signed but didn't have any enforcement behind them. There weren't commissions or committees to oversee the regulations, and if there were, they weren't given the power to implement any kind of punishment to the companies who didn't comply. As far back as 1941, President Roosevelt issued Executive Order 8802, which stated, I do hereby reaffirm the policy of the United States that there shall be no discrimination in the employment of workers in defense industries or government because of race, creed, color, or national origin. So President Roosevelt was trying to eliminate this discrimination, at least for the government workers. Executive Order 9981 was signed by President Truman in 1948. This stated, it is hereby declared to be the policy of the President that there shall be equality of treatment and opportunity for all persons in the armed services, without regard to race, color, religion, or national origin. So although the intention here was to eliminate discrimination, again, because there wasn't enforcement, we didn't actually see much integration until the Korean War in the 1950s. In 1961, President Kennedy issued Executive Order 10925, which stated, there is hereby established the President's Committee on Equal Employment Opportunity. So here we get a committee that is tasked with enforcement. The order reaffirmed that government contractors could not discriminate, and if they did, now there was a committee that had some actions that they could take. Namely, they could end a contract, which was the big deterrent. And then they were put on a list of companies that had discriminated and may not get future contracts because they were on this list. 2 years later, under President Kennedy, the Equal Pay Act of 1963 was passed. This stated that payment could not be different for men and women who did essentially the same job, the same work. For a view of the current state of equality, or inequality as it stands, make sure to read the section in the Riggio textbook in Chapter 3 under Job Evaluation. In the following year, in 1964, under President Johnson, came the legislation that most of us are familiar with, the Civil Rights Act of 1964, specifically Title VII, which deals with employment. So what does this actually say? For companies that have 25 or more employees, quote, "It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin." So here's combined both the sex discrimination and the other categories that were mentioned previously with Truman and Roosevelt's executive orders. So these 5 categories create what are known as protected groups, who have historically been prevented from having the same opportunities as the majority and those in power. In 1967, the Age Discrimination in Employment Act was passed. And this said, the purpose of this act to promote employment of older persons based on their ability rather than age, to prohibit arbitrary age discrimination in employment, to help employers and workers find ways of meeting problems arising from the impact of age on employment. And this specifically pointed out the age of those who were 40 and older. We have a few more things that passed in the following years. The Equal Employment Opportunity Act of 1972, which amended Title VII to give the EEOC some teeth to enforce those regulations. And companies now included those with 15 or more employees. So this increased the number of companies that were included in this legislation. Previously, it had been 25 or more employees. In 1973, the Rehabilitation Act was passed. The federal government, as an employer, cannot discriminate against qualified individuals with disabilities. This is a precursor to the Americans with Disabilities Act, which will cover other employers as well in 1990. The Pregnancy Discrimination Act of 1978 was passed and stated that discriminating based on pregnancy is a form of sex discrimination. So in 1990 came the Americans with Disabilities Act. No covered entity shall discriminate against a qualified individual with a disability because of the disability of such individual in regard to job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. So many personnel decisions are included in this as well as the other anti-discrimination laws. So in these regulations, this includes making reasonable accommodation for those with disabilities. We need to know what the job is based on our job analysis and see what would need to be changed in order to allow someone with a disability to perform that job. And so long as it does not cause undue burden to the employer should be making these accommodations. So to review, there were several pieces of legislation passed for each of these different categories. Sex in 1963 and 64, race, creed, color, and national origin in 48, 41, 48, and 64. Age in 1967, and there were later updates to that afterwards. Disability in 1973 and 1990. And just in the year 2000, President Clinton signed Executive Order 13145, which stated, "It is the policy of the government of the United States to provide equal employment opportunity in federal employment for all qualified persons and to prohibit discrimination against employees based on protected genetic information or information about a request for or the receipt of genetic services." It applies to every aspect of federal employment. So this was passed soon after the human genome was mapped. And there was concern about what having that information would do to people and if people would start discriminating against others because of it. So I encourage you to take some time and explore the EEOC website. The specific site I have put here is a listing of the laws that are currently in place. There is also a good history, and that reference, the link I have put in the references at the end of this presentation. So for a brief overview of what is currently in place, most laws apply to private companies with 15 or more employees, and this is defined by 15 or more employees working 20 or more weeks a year. For age discrimination, this is any company having 20 or more employees for 20 or more weeks a year. For equal pay for sex differences, the size of the company doesn't matter. Everyone needs to follow those regulations. And government entities are subject to all the discrimination laws. All workplaces should have a poster stating employee rights in regards to discrimination in the workplace. You've probably seen this if you have a job. It's often located in the employee break room or by a copy machine, somewhere where all or most employees would frequent. So if you are working right now, see if you can find your poster and take a look at that. I want to talk now about a court case that has had a big impact on how the laws are implemented. In the Supreme Court case, Griggs versus Duke Power Company in 1971, 13 African American employees of Duke Power Company's Dan's River Steam Station in North Carolina petitioned that the qualifications of a high school diploma and passing of a general intelligence test were discriminatory. The company had implemented these qualifications after the Civil Rights Act of 1964 was passed. Previous to that, they didn't have this requirement of people in order to get hired. The Supreme Court concluded then that intention to discriminate or not doesn't matter. It is whether a test or qualification is job-related. In this case, the company could not show that those qualifications were job-related. Because they had previously hired people without those requirements, they had the opportunity to see whether it made a difference. And it did not. There were employees who had been hired without a high school diploma, and they were able to perform the job just fine. So they have to show what the job is, like we've talked about, using job analysis, and that it's a valid procedure, that study results, and they do that by showing study results where the selection procedures predict performance scores in that particular job. In order to give guidance to employers on how to comply with anti-discrimination laws and ensure that they are prepared to back up their procedures, to have the records to show they don't have a discriminatory process, the EEOC issued guidelines for employee testing and selection. The first version of this was issued in 1966, soon after the EEOC was created. And a later version was issued in 1978. And although it seems like quite a while ago, these are the uniform guidelines that we still use to this day. Because it shows how to demonstrate that selection tests and procedures are valid and that they do not have an adverse impact. These standards have not changed. So what is adverse treatment? And is that different from adverse impact? Adverse treatment is an intentional discrimination in hiring and other personnel decisions against protected groups. It is purposely using instruments or assessments that have different levels of performance for different groups. For example, in the Griggs versus Duke Power Company, the use of high school diplomas. When it's known that one group is less likely to have that diploma, and it is used as a tool then to prevent those people from becoming employees. That is an intentional discrimination. What we would call adverse treatment. What we would call adverse treatment. Adverse impact, on the other hand, is not intentional, but yet the procedures still disproportionately affect protected groups in a negative way. So it's using maybe a test score that has average differences for different groups, and not intending for it to be a problem, but yet it treats the subgroups differently. It results in some subgroups having less chance of getting hired or getting promotions, etc. I want to point out that these are group-oriented concepts. The adverse treatment and adverse impact are looking at the whole group of people. You need to be able to show that the ratio of hiring or of promotions is different for different groups as a whole. You can have discrimination against an individual, but you have adverse impact against a group. So how do we know if a group is discriminated against? We use what is called the 4/5 rule, and this is laid out in those uniform guidelines I discussed. The 4/5 rule, or the 80% rule, is essentially a cutoff to determine what is or is not discriminating. It is essentially a cutoff score to show what is or is not having an adverse impact on protected groups. So this is how we determine whether there is adverse impact. If there is differential selection, specifically when the selection rate for a subgroup, whether it be race, sex, ethnic group, or other protected groups, is less than 4/5 or 80% of the highest selection rate of the subgroups. So for example, and I'm going to keep it simple here with only having two groups. If we have 100 white applicants and we hire 60 of those, we have a selection rate of 80%. If we have 50 black applicants and we hire only 10 of those, that selection rate is 20%. We need to take the ratio of that to determine how big that difference is. The ratio of Black to white hiring is 33%. We aim for a higher number, and we want to be above that 80%. So this is unacceptable. Let's change the numbers here a little bit to take another look. If we have 100 white applicants and we hire 24 of those, we have a 24% rate. And if we continue to have 10 of 50 Blacks hired, we have that 20% rate. If we take the ratio of these, this is an 83%. So this is acceptable legally. Of course, our ideal is to reach 100%. We'd like to have every company aiming to have a totally equal hiring rate of all of our subgroups. Because there is variability in everything, the numbers will rarely match up. It may be 99.3% or 102.1%. But 100% is what we're striving for. That would be an equal selection rate. Legally, however, companies need to be able to show they are above the 80% mark on the ratio of hiring rates for all protected groups. It is the responsibility of the organization to maintain records that show this. IO psychologists are particularly equipped to help companies create and maintain these records, and there are many consulting firms that have this as their focus. So here are several references. Like I said, take some time to look at those EEOC laws and history. It's very informative. And the uniform guidelines show us some details on how companies should go about creating and maintaining their records to show that their selection procedures are valid.